Hi, I'm Akash, and today we're going to be talking about copyrights, one of the basic forms of intellectual property. We'll go over what can be copyrighted, what is subject to a copyright, and then go over some key features that discuss how a copyright is different from other forms of intellectual property. Copyright is a type of intellectual property that protects creative works. Now, creative works is a broad heading, but it includes things like literary works, which are books, articles, and newspapers, dramatic works, which is film, television, plays, and so on, musical works, such as sound recordings, compositions, songs, and other artistic works, like sculpture, paintings, and art installations. Now, the concept of a creative work can seem fairly intuitive, but there are a few unusual applications, areas where copyright applies that you would not necessarily assume. For example, software, which at its core is a written-out series of code, fits much more neatly into the regime of copyright than patent, even though it is a technological creation. Similarly, databases fall into the regime of copyright law, even though it's just a list of information within the concept of Indian copyright law. So now that we've gone over some of the basics of a copyright, let's discuss the key features of copyrights that differentiate them from other forms of intellectual property, like patents, trademarks, trade secrets, and the like. Now, there are several key features of copyright that make it different from other forms of intellectual property. The first is that a copyright is created at creation, which is to say that when you register a copyright, that registration does not in and of itself create your copyright. The copyright exists the minute the work was put down in tangible form. It's an inherent right of the creator. The second aspect is that copyright can be enforced internationally. Now, through convention and the enforcement of WIPO, which is a subdivision of the World Trade Organization, all WTO member nations are required to recognize copyrights issued in any WTO member nation. So that means that no matter what country you got your copyright registered in, no matter what company you created your work in, it is enforceable in any jurisdiction. And finally, there's the fair use exception, which is a fairly broad limitation on the ability to enforce your copyright. Now, there are a few caveats to the fair use exception, and we can go into these in a subsequent video. But this is a broad exception that is not present to a similar degree in other forms of intellectual property. So as you can see, copyrights are a useful tool for protecting your creative works. There are many key features that make it a very strong form of intellectual property. And if you want to know how a copyright can help protect your work from infringement, please consult an intellectual property attorney. Hi, I'm Akash, and today we're going to be talking about another form of intellectual property, patents. Now, along with copyrights and trademarks, patents form one of the central pillars of the intellectual property regime, whereas copyrights focus on creative works and trademarks focus on brands and corporate identities, the patent focuses on scientific and technological advancements. So first, let's take a look at what makes a patent. What is, in a sense, patentable? A patent is a type of intellectual property that protects scientific achievements. Now, this achievement can take the form of a device, a product, or a technological advancement. But it should be noted that a patent will only protect the application of science, not raw science itself. What this means is a scientific discovery itself is not eligible for patent protection. You need to have a practical application of science in order to apply for a patent. Now, patents come in two broad categories: a process patent, which is a patent over the method for creating something, and a product patent, which is an object, an item, or a device. Now, the exact differentiation between a process patent and a product patent can get a little bit fuzzy and has been the subject of some international dispute. So we can discuss that in more detail later on, but it's important to understand these broad headings in order to understand what a patent can protect. Now, just because you've invented something doesn't necessarily mean that you'll be able to get a patent on it. In order to be patentable, an invention needs to satisfy 3 criteria. Let's take a look at what they are. In order to be eligible for a patent, an invention needs to satisfy 3 criteria. It has to be novel, non-obvious, and useful. Now, to be novel, an invention needs to be one that hasn't been discovered or disclosed before. That means that nobody has got a patent on it, nobody has applied for a patent on it, nobody has published it, and it's something that is not known outside of you and your associates. To be non-obvious, your invention needs to have some inventive step above and beyond that which is already known in your field. Now, the standard by which this is judged is the person ordinarily skilled in the art. So, for example, if your invention is in the field of radiology, if someone ordinarily skilled in radiology could easily intuit the discovery that you are trying to get a patent over, it will be considered an obvious patent, and you won't meet this criterion and won't be getting a patent. So it has to have a step above the currently known state of the art. And finally, an invention has to be useful. That means that it has to be capable of industrial application. You have to be able to make something useful from it. A frivolous invention that won't deliver any result or is impractical to be applied in the industry generally will not be eligible for a patent. So as you can see, a patent is a useful form of intellectual property when you're looking to protect your inventions or scientific discoveries. To figure out whether your work can be protected by a patent, consult an intellectual property attorney. Hi, I'm Akash Kashyap, and today we're going to be talking about another form of intellectual property, the trademark. Now, unlike other forms of intellectual property, trademarks are designed to protect the reputation and goodwill of their holder. Now, a trademark refers to a name, a slogan, a brand, a design, or a logo that the holder uses to conduct business. And the trademark gives them the exclusive right to use that in order to prevent others from taking advantage of their reputation or damaging their reputation. Today we're going to go into the specifics of what forms a trademark and what can be registered as a trademark, and then some key features of trademarks. Let's start by going into what a trademark is.
At its core, a trademark is a signifier. It's one thing that represents another thing. Now, what it signifies can vary. It can signify a company, it can signify a brand, or it can signify a product. For example, let's take the company Warner Brothers. Now, any logo, name, or slogan that represents Warner Brothers can be considered a trademark. Similarly, one of their brands, such as DC Comics, can also be represented by names, slogans, logos, etc., and those would also be considered trademarkable. And beyond that, if you take a specific product that they offer, such as the film The Dark Knight, that would also have its own representatives, names, slogans, and logos that would themselves be valid to trademark. Now, this brings us to the form that a trademark can take. A trademark can generally be in 3 forms. The first is a design, which is an arrangement of shapes or other visual elements to form a identifiable design. The second is a phrase, which is a combination of one or more words in a specific order. And the third is a sign, which is a combination of a phrase and a design. The owner of a trademark, the person that has the sole right to use it, can be an individual, a single person, a business, which is any type of business organization, or even another type of organization. For example, nonprofits like the NRDC, they are also eligible to have trademarks that protect their names and their logos, designs, what have you.
So as you can see, a trademark is essentially a symbol, something used to represent its holder. Now, let's look at some key features of a trademark, how it operates, and what separates it from other forms of intellectual property.
Now, when it comes to discussing the key features of the trademark, there are essentially three that make it different from other forms of intellectual property. The first is that it's geographically limited. The second, that by and large it's restricted by industry. And the third, that it's restricted by type. Now, when it comes to the geographic limitations, essentially trademarks are restricted both by the region in which they are actually used and the regions in which they are registered. So a logo or slogan or even a name, no matter how prominent, will never have universal applicability. It'll always be applied in a geographically limited region or a series of geographically limited regions. And places where the trademark is neither used nor registered will not be obligated to honor the restrictions on use of the trademark. And in those regions, the design, the phrase, or the sign will be entirely open for use by others. Similarly, the trademark will be restricted by industry. Now, the way this is generally done across jurisdictions is that trademarks and the registry of trademarks will be divided into a series of classes. And these classes are collections of industries and uses that are associated with one another. And a trademark will only be granted in a specific class or in a series of classes, and the restrictions of the trademark will only prevent others from using the trademark or using a substantially similar mark within the same industries that it's protected. What that basically means is that the trademark protects the industrial use of your design, phrase, or sign. For example, if you have a hospital that is operating under the name Apollo, that is a trademarkable name, but that doesn't mean that, for instance, a comic book store cannot be opened with the same name, because the registration of the name is specific to the class or classes that apply to that industry. The final type of restriction is by type. Now, in several jurisdictions, India included, there are different types of registration that can happen even within the same class. In India, for example, it's divided into a design trademark and a word trademark. A design trademark refers to a visual arrangement. It's a combination of words and other visual elements in a specific way. Whereas a word registration is a trademark that applies only to the arrangement of words.
So trademarks, in a sense, are a way to represent your reputation in a business. And because of that, it is essential to register and protect your trademark in whatever arena you plan to go into business. In order to understand how to protect your trademark, your brands, your logos, your slogans, consult an intellectual property attorney. Hi, I'm Akash Kashyap. Today we're going to be talking about one of the more unusual forms of intellectual property, the trade secret. Now, a trade secret refers to information that is valuable for a company or business by virtue of its secrecy. And that secrecy is, under certain circumstances, legally protected. So we're going to look at what type of information is protected, what criterion have to be met to constitute a trade secret, and what exactly the protections are that are available to a trade secret. So first, let's take a look at what type of information can be considered a trade secret.
At its core, a trade secret protects information that provides a competitive edge through and by virtue of secrecy. Now, there are a couple of different types of information that will fall under this heading, but this is the key principle to keep in mind when deciding whether your information can be considered a trade secret or not. Now, one type of information that's often considered a trade secret is technical information. This can include information about a manufacturing process, information about specifications and design for a product, formulas and recipes, software codes, and other forms of technical information. Another type is commercial information. This can be distribution methods, supplier lists, client lists, market strategies, and financial information of all types. Essentially, this is information about your business and about how you conduct your business, with whom you conduct your business, and how you plan to take your business forward. A key thing to keep in mind is that trade secrets don't necessarily need to be made of secret components. A combination of information that is in the public sphere, as long as the combination is not in the public sphere, can be a perfectly valid trade secret. If you take 3 different pieces of information that everyone knows about, but put it together in a way that is not known, that is a perfectly valid piece of information for trade secret protection.
Now, not all of the information that we just discussed is going to be eligible for protection as a trade secret. There are some additional criterion that any individual piece of information needs to satisfy in order to gain the level of protection of a trade secret. Let's take a look at what these criterion are.
So what turns a piece of information that can be a trade secret into a trade secret? By and large, there are 3 criterion. First, that the information has value through secrecy. Second, that the information is actually secret. And third, that the holder of the information has made a commitment to secrecy. Now, when you're demonstrating that the information has value through secrecy, you have to show 2 things. One, that that information has commercial value, that it is something essential to your profitability, to your success as a business. And second, that if that information is disclosed, that value will be lost. The information will be much less valuable. Second, you have to demonstrate that it's secret, which is to say you have to show that only a limited group of people have access or knowledge to this information. And third, you have to demonstrate a commitment to secrecy. Simply because something is valuable and a number of countable individuals hold that information, that doesn't mean that it is a trade secret. You also have to show that there is an intention and a commitment to keeping that information secret. That means you have to show that there are reasonable steps taken to ensure secrecy. You need to show that there are confidentiality or non-disclosure agreements at a minimum that are keeping those this information is disclosed to from spreading the information further. You also have to show that you've taken additional steps to protect the information from leaks and unauthorized access.
Now, given that you have a piece of information that is of the type that can be protected by a trade secret and satisfies the criterion of trade secrets, there are some protections that are going to be available to you in order to preserve the secrecy and hence the value of your trade secret. Let's look at what those protections are.
There are 3 key features of a trade secret that make it different from other forms of intellectual property. First, the protection of a trade secret depends entirely on the secrecy that it's maintained in. What that means is if there's public disclosure of the trade secret, that trade secret can't be protected anymore. This is not true for intellectual property like trademarks, which are always known to the public, or patents or copyrights, which, as long as they aren't disclosed prior to registration, still maintain their protection. But a trade secret loses its protection once it's known to the public. Second, the extent of protection is limited to the means of discovery. Now, what that means is that a trade secret protection will bar industrial or commercial espionage and will give you causes of action for breach of confidence. So if someone acquires the information by getting through the protections that you have put in place to maintain secrecy, the trade secret protection will allow you to stop them, to pursue them. It is essentially a protection against unfair competition. But what that means is that there isn't a defensive use of this. So if someone applies for a patent or a copyright on information that you have protected through a trade secret, you can't restrict them simply on the basis that you have applied a trade secret, that you have that protection. Similarly, if someone discovers this information parallelly, if they independently arrive at the same information, then you can't bar their use of the information. The only thing that the trade secret will protect is other people piercing the veil of secrecy that you put around that information.
So as you can see, a trade secret is quite an unusual form of intellectual property. It's not one that requires or indeed can be registered. It's not one that can be used to defend against the registration of other forms of intellectual property. And it's not really one that exists in the nature of the work itself. It's something that's preserved through secrecy and can just as easily be lost. However, for information that is key to your business's success, a trade secret can be a very useful way of making sure that no leaks occur and that you're able to protect the privacy of your information. As always, please consult an intellectual property attorney in order to gain more information on anything that you have that can be given protection as a trade secret.
Thank you for watching. If you like this video, please like, comment with your thoughts, share it with friends and family, and subscribe to see more content.